Hello, Iowa Realtors. Welcome back for another legal breakdown video. This one's a little bit different. We are here with Jodie McDougal, lead counsel for IAR on a very important case that could literally have drastic effects on thousands of our members. Jodie was with the Dentons Davis Brown law firm. Jodie, just thank you for being here. Tell us a little bit about this case.
All right. Well, thanks, Gabe. I'm glad to be here and glad to give the group a legal update. So the case is, well, let me start with this. How Iowa Association of Realtors got involved and the National Association of Realtors got involved was because this case was on appeal. So it started as a lower level decision, and then when it goes on appeal, then there's an opportunity for groups to ask the court if they could submit a brief to help the court. It's called an amicus brief. Mm-hmm. And so you all were nice enough to call me.
That's right.
And we filed a motion with the Supreme Court to ask if we could submit our own amicus brief. And the point of that is we can give our perspective, you know, the thousands of realtors here in the association, the million plus in the National Association of Realtors, can give our practical advice and perspective to the Supreme Court, and then also some additional legal arguments. So that's how we're involved. The parties of the case involve a prospective buyer. Her name is Amanda DeSouza, and the defendants are the sellers or the owners of the house that was listed, that's involved in the matter, the realty company, who's our realty, and then the individual listing agent. Okay, here are the facts of the case. So Ms. DeSouza was a prospective buyer wanting to see a house. And so her agent at another realty company requested a private showing through the app that you all use.
Yep.
Okay.
Showing time here in the Des Moines market.
Yes.
Yep.
Exactly. And we know everyone's got little different apps, but this is how we do things now.
For sure. For
right?
sure.
A lot better. So this prospective buyer's agent submitted a request for a private showing. So this was one where the homeowners, the sellers, weren't even living in the house. So they had moved to their new residence. Listing agent wasn't at the house. This is one where the private showings were automatically approved. So again, go on the app, buyer's agent says, you know, I want a private showing. It's automatically approved, and they go over there. So the buyer and the buyer's agent goes over there on a Iowa winter morning, snow and ice, clearly not a good time to be driving around.
It's like yesterday.
Yes. And when she gets there, she slips and falls. So the buyer gets out of the car, slips and falls, which is unfortunate, obviously.
Yeah.
Okay, so this is a situation where the listing agent didn't even know the private showing was happening, wasn't at the private showing. It wasn't an open house.
Right.
Okay. So agent wasn't there, didn't know what was happening, wasn't at the property before, during, or after. Notwithstanding, the prospective buyer sued not only the homeowners, which we expect, right? Mm-hmm. But they sued the listing agent and then the realty company, the company of the listing agent. So that's a big shock, I think, when
absolutely.
A realty company gets brought in like that. So those are the underlying facts.
And of course, here in this case, trying to remember the facts for sure, but there wasn't any like property management agreement in place or anything like that in this case, right? I mean, this was just a company that was hired to list and market the property and try to procure buyers.
Yep. No duties that the agent had in that regard. The other thing I think that's important is this was a slip and fall on ice. It wasn't like a slip and fall on faulty stairs that maybe the listing agent knew about or anything. This is just, you know, an open and obvious condition.
Yeah, absolutely. And Jodie, we filed the amicus brief in front of the Supreme Court, and a lot of the arguments were obviously what other states, right? Cases from other states, how this issue's been decided in other courts, as well as sort of public policy arguments. But is there a case like this one in Iowa?
Not quite. So, and that's why it's an important case for this association and for the parties involved. So in the underlying case, Iowa Realty filed a motion for summary judgment. And a motion for summary judgment is a motion you file before you get to the trial. And there you're asking the court to just dismiss the case because of a legal principle here.
Right.
So Iowa Realty expected their motion for summary judgment to get granted because the argument, the much better argument, is that there is no legal duty that could exist from a listing agent to prospective buyers that tour a house alone without the listing agent.
Right.
So that's the legal question. And then the lower court decided in its summary judgment ruling that yes, there could be a duty there. Okay, and so that's what started the appeal. And so there wasn't a case in Iowa where the Supreme Court had said, without a doubt, that there's no duty of a listing agent. There was no case law either way.
Yep.
So then, as you pointed out in the brief, we focused on out-of-state case law.
And when you look at these out-of-state cases, I mean, the law is really in a lot of these states on our side.
Yes.
There really weren't any examples that we found, were there, of an off-site listing agent in such a situation like this one,
Nope.
having liability imposed?
No, I had an easy lift on this one. So I had a lot of good supportive case law from across the country. And in almost all of those cases, in this type of setting, which is not an open house, courts rule that a listing agent doesn't have a duty to a buyer. There are a few exceptions, so open houses like I just mentioned, or if the listing agent had some better knowledge. Again, if you had a staircase, if you had let's say a huge hole in the floor that was covered up with a rug, so a dangerous condition that was hidden, the listing agent knew about it, that'd be different.
Right.
But in all the cases that are like this case, factually speaking, all those courts ruled there's no legal duty, you don't even go to trial. The realtor gets dismissed out.
Right. And you look at so you look at those cases, but then the policy arguments, right?
Yeah.
We talked a lot about in the Des Moines market here, right? The application showing time.
Yeah.
The last couple years, the market has been very hot.
Yep.
Multiple offers galore.
Yeah.
These things like showing time, private showings, obviously create massive efficiencies.
Yes.
But if this case goes the wrong way, I mean, at its worst, don't those applications, those private showings, I mean, isn't the listing agent really going to need to be there if this goes the wrong way?
Yeah, well, I would say all of your members are going to have their work cut out for them, trying to deal with it if this decision goes badly, because, I mean, the efficiency of lock boxes and private tours and all of that, and that's what everyone wants, right? If you're a buyer's agent, you don't really want the seller's agent hanging around.
No, absolutely not.
You want to go in, go through, but yeah, if the case turns out negatively, it could change a lot of how we do things. And then the other ramification is, like in this case, insurance companies. So insurance companies insure risk, and then insurance companies have to come in for our realty or the realtor, and then what that means is premiums go up, and eventually I think that cost would get passed down to the buyers and sellers.
In some way, shape, or form.
Yes.
Absolutely. What do you see in this case as sort of the possible outcomes?
Okay, well, we talked about
there's
this.
A few.
It's a loaded question. So there are a few. We're hoping for a positive outcome. So the Supreme Court could decide to make a narrow ruling just on this case, or could decide to do a broader ruling,
right?
Positive or negative.
Yep.
So there are a lot of things that could happen. I mean, our hope, obviously, is that the Supreme Court looks at the facts and hopefully also looks at sort of this general fact pattern and says, here, a listing agent absolutely does not owe a legal duty to the buyer.
For sure.
Yep.
For sure. Absolutely. And this particular case, it's going to be oral arguments on March 24th, 1:30 p.m.
Yep.
So if our members were interested in viewing the case, how would they do that?
Yep. Okay, so March 24th at 1:30. So a couple options. The oral arguments are at the Judicial Building downtown right by the Capitol. So you and I are going to be there.
Absolutely.
And we don't get to argue, unfortunately, but we'll sit there and we'll listen to the arguments. And then as of a couple years ago, the Supreme Court started live streaming arguments, so that's great. So I think on your website right now probably is the link, or it will be a link to the live stream option. So everyone can log on and watch it, or come down with us and watch it in person. One just logistical note is that there are 3 cases that are usually scheduled during that 1:30 slot. And we don't know the order yet, and we'll let members know. So our argument might start at 1:30 or 2 or 2:30.
And then kind of after that, could take a few months maybe to get a decision one way or the other.
Yep, so waiting game. Justice is not fast.
Yeah.
Obviously the briefs were submitted many months ago, and then we'll have our argument. And it could be realistically anywhere from 3 to 6 months after that, or maybe even a little longer.
Okay. Well, Jodie, I just want to say on behalf of our over 8,000 members here at the Iowa Association of Realtors, we genuinely appreciate you taking the lead on this case for us.
Thank you.
The brief was outstanding, and we definitely feel like we'll be able to be heard in front of the court through that brief. And just thank you for everything you do for our industry. So,
Thank you.
And thanks for being here today.
Thank you. You're welcome. And I appreciate you guys trusting me with the work, and I hope it goes well.
Absolutely.
Thank you.
We'll see you next time.